Good afternoon, ladies and gentlemen. It is now 5 o'clock in South Africa, so good morning to those of you in Canada. This is the second webinar for Introduction to Medical Law. So I hope you can all hear me. If you can't, then just indicate to me, and I'm going to share my screen with you. So indicate to me if you cannot see the screen and if you cannot hear me. Otherwise, I accept that everything is fine. So once again, welcome to this second webinar of Introduction to Medical Law. As you all know by now, I am Professor Magda Slabbert. I am a professor at the University of South Africa, and I do the webinars. I'm in charge of the activities, but your real facilitator is Bonnie Venter. And I think you have all seen what she does and made contact with her in some or other way. Okay, so just to welcome a few administrative matters. Remember, you are just one group, and for all your administrative matters, you have to contact Grace Makuru, as we cannot help you with administrative matters. But if it is matters concerning the content or the course itself, then you are welcome to contact either me or Bonnie, or post your question on the forum that is provided for you. So in our previous webinar, we discussed the Constitution and the effect that it has on medical law. And we touched on the law of contract and the law of delict. So just once again, general matters. Keep your eye on the schedule to see when you have to do what. If I am correct, the test one opened on the 1st of April and it will close on the 12th of May. So check your schedule that you don't miss out on test one, because once it closed, we cannot open it again. Remember that Bonnie is online once a week, not with an engagement as what I am doing now, but she will then attend to questions that you might have. Then also read all the announcements, or I know that Bonnie also publish it under extra reading for activities, so that you keep updated with new developments or new things that are posted there. And then do the activities as you receive them. Otherwise, you are going to run out of time. And I cannot emphasize this enough. If you do not keep up with the activities, you are going to run out of time, because we expect of you to do a lot of reading. So it is time consuming, although the questions are quite easy. And as I've said previously, it's like a comprehension test that you did at school, but the reading might take some time, because the purpose of the activity is that you should read the whole case and then answer the question. So plan your time. Remember, you are welcome to speak to each other, to ask for help on the forum. But at the end of the day, when you submit your work, then you have to do your own work. And then, as I've also said last time, never give up. You've paid a lot of money for this course, and we want you to pass. And as I've said, if you pass, you should feel extremely proud of yourself, because the quality of this module is high. We expect quite a lot of you. So if you pass it, then you can be and you should feel very proud of yourself. Just before I come to the portfolios, test one is only on the theory. In other words, all the extra work that we post on the website, or the court cases for the activities, you do not have to study that for test one. Test one is purely based on the theory that you have under all the different units. So you only go through that theory. And then once you feel comfortable that you have mastered the content, then you do test one, which will then count 20% of your final mark. But I emphasize again, you do not have to study all the extra information or the activities for your test one. Test one is only the theory that you will find on your website. Okay, now let's talk about the portfolio. Let me just quickly, yeah, just mute yourself, please, and switch off your cameras. Otherwise, it takes too much data. And if your microphone is open, then it disturbs us. So just switch off your microphone and your cameras, please. Okay, so the portfolios are 80% of your final mark. And I think you've done the first two, if I'm correct. So you've seen what the way I'm going or what I am asking of you. And honestly, the questions are not difficult. It's just the reading. The reading takes time. But put in an effort. As I said also previously, the questions are broader than the study guide. Why? Because we want you to see the theory in practice. In other words, we want you to see how the courts apply the theory. It is one thing to understand and know the theory, but it is completely different if you have to apply the theory to actual cases. And that is why we think that you will learn so much more by reading the different court cases. Ask if you need help. I've also emphasized last time, I know that a lot of you are lawyers, either attorneys or advocates, and your work scenario can change quickly with cases coming up, deadlines to be met. If you then fall behind, please notify me and Bonnie in time. We will look at your individual scenario, and then we can, depending on the circumstances, grant extension. Okay, that then concerns the general things which I've done in detail last time. Webinar 1, the PowerPoint is also on your website, and tonight when I finish, I will send the PowerPoint to Bonnie and she will upload it. Unfortunately, the recording is not available. So you will be able to see the slides and look at them again, but unfortunately, they do not make available the recording of what I am saying. Then you will see there on your screen that I have highlighted in yellow the specific case, Mbele versus MEC for Health for Gauteng. That is a very nice case. You will see it is a Supreme Court of Appeal case. And in that case, you will see an exception where pain and suffering was paid out. It is a woman who gave birth. The baby was stillborn, yet she was taken back to the maternity ward and she had to identify the little body, and she went completely depressed and she needed psychiatric help, etc. And then the court, if I'm correct, allowed 100,000 for pain and suffering. But remember, last time I told you of the example. If my son dies in hospital because of medical negligence while he is a student and not supporting anyone, not a breadwinner or whatever, then actually I cannot institute action because there's no damages to be proven except my pain and suffering. But the courts will not pay out pain and suffering just generally. I will have to end up in a psychiatric institution and have actual proof of costs for my pain and suffering. In the same example, I've said if my son is in an accident and there's medical negligence and he is a paraplegic because of the negligence, then of course one can institute a claim for damages, which will include pain and suffering for him, as well as the loss of amenities of life, as well as past and present medical expenses. I'll come back to this as well. But I just thought that I will refer you to that case because in that case, baby was stillborn, yet the mother was successful with a claim of pain and suffering, but she could actually prove her pain and suffering. Okay, so that is just sort of background, and then still under general. The case of ES versus AC is a Namibian case, but that I would like you to take cognizance of, because in that case, it was a balancing of human rights. It's actually a very interesting case. It is a Jehovah's Witness, and she fell pregnant. She had other children, and she fell pregnant, and she told her husband to take control should she not be able to, because she does not want a blood transfusion. The Jehovah's Witnesses are against a blood transfusion. And then it happened that while she was giving birth, things went terribly wrong, and she had to get an emergency hysterectomy. And then her husband stepped in and said that they're not allowed to give her a blood transfusion. Her brother also became part. He went to court. He's from a different faith. And he said to the court, but the life of his sister is more important than the religion. The court went on and the case went on. She eventually survived without getting a blood transfusion. And then she went to court. Namibia does not have a constitutional court, so she went to their highest court, which is the appellate division. 3 judges heard the case and said 2 of the judges said her autonomy, her decision, is the deciding factor. And the one dissenting judge said, no, the interest of the children should be taken into account, and that should trump the autonomy of the woman. But the majority judgment stands. In other words, the autonomy of the woman. If she decides no blood transfusion, then there will not be a blood transfusion, irrespective of whether it is in the best interest of the children that they should have a mother. The personal autonomy in that case trumps the rights of the children to grow up with a mother. So it's quite an interesting case to see how human rights are weighed up against each other, and then the conclusion that the autonomy of the woman is the deciding factor. NC versus Engelbrecht. I want you to see that case because it touches on wrongful life, wrongful birth, and wrongful pregnancy. And it is a claim based on contract and delict, and there are experts involved. So that will open up to you what I did in the previous webinar, saying that you can sue a doctor on the basis of a contract, or on the basis of a delict, or on both. In that specific case, it was done on both. Wrongful life, wrongful birth, and wrongful pregnancy, I will touch on in the next webinar. Then the Van der Walt case, and that is also a question in your assignment, is terrible. And I honestly beg of you to read the High Court case as well as the Constitutional Court case. And then sit back, close your eyes, and think. And think. Because this is a sad case. It is one of few in South Africa. The other one, I think, was in 1948, and the last one in 1965. And then suddenly this one came, of a gynecologist. The woman was small. He advised her not to give birth naturally, yet she did. She reminded him that she wanted to give birth naturally. He should have known in a case like that, that there will be problems of getting the baby out. So when he arrived while she was giving birth, it was alleged by her mother that he was drunk. He couldn't get the baby out. He eventually put in his whole arm to get the baby out. And there was a tear from her vagina to her anus. He didn't stitch it up correctly, and she eventually bled to death. So that case originally went to the regional court in Mpumalanga, in Mbombela, and the regional magistrate found him guilty of medical negligence, and he was sentenced for 5 years imprisonment. He then appealed to the High Court in Mpumalanga, and they dismissed the appeal. He was not allowed to go to the Supreme Court of Appeal, so he approached the Constitutional Court. Now, unfortunately, the Constitutional Court only focused on the procedure in the regional court. And our constitution say that every person has the right to a fair trial. And he said he did not have a fair trial because the regional magistrate only pronounced on the admissibility of certain evidential material at the end when she gave judgment. And then he was deprived of giving evidence himself. That is what he said, but he never gave evidence, nor did he call witnesses. So he said he was deprived of a fair trial, and he also objected against the regional magistrate using medical law books in order to clarify what the expert witness have testified, and that was also irregular. So the judgment in the Constitutional Court was in his favor. And because they said that it was the procedures in the regional court was irregular, then of course the sentence fell away as well. They referred it back to the National Director of Public Prosecutions, and they have to decide whether to institute an action de novo in front of a new regional magistrates court. But as far as I have ascertained, they're not going to do it. He already spent some time in prison, but yeah, it is an extremely interesting case, and it's an alarming case. And if I want you to read the High Court case as well as the Constitutional Court case. And as I've said, then sit back, close your eyes, and think at the end of the day what is fair and what is not fair. And that is why I say medical law is so extremely interesting. It is because there's sometimes not a black and white answer. There's an overlap of ethics, there's an overlap of a feeling that something's not right, etc. But it's for you to decide. Read the case and you make up your own mind whether you agree with me or not. It's not that I am correct in everything. I just read these things and then you get a kind of a feeling. The next case, IN versus MEC. That case is also asked, I think, in an activity because I want you to show what some attorneys, remember, just as there are bad doctors, as we see in the Van der Walt case, there are also not so good attorneys. So if you read the case, just see that case selection is not a good thing. It shouldn't be done. That case also touches on prescription. So while you see the selection of cases by the attorney's firm, you also see how prescription comes into play. And then I want you to see the sad part of a mother and a father and a child. Is in the middle of the whole case, yet it is played around them concerning attorneys and prescription and whatever. And all that they want are answers of what happened to their child. So there's a little bit of sadness as well. And then MEC versus PM, that concerns a lump sum, and it refers back to the DZ case. The DZ case you have to take cognizance of, because in the DZ case, it was said in the Constitutional Court that the door is open for change, in that damages need not be paid out in one lump sum at one time anymore. In other words, when there are cases of cerebral palsy, it depends on the case and it depends on which court, and that court can make a ruling. Instead of paying out a lump sum for damages, the court can rule that the child should get all the facilities free from the hospital, which is of course free for children at a public hospital. But if the public hospital is not up to standard, then the same procedure should be provided privately, and then it must be paid for. That is now physiotherapist and speech therapist and things like that. So I just want you to take note of that case. The De Bruyn case, I'm going to leave a little bit because it is the process at the HPCSA, and next time in the next webinar, I'm going to speak about the disciplinary process at the HPCSA, etc. So last time I told you about the South African Law Reform Commission, and I urged you to go to their website and read the project on medico-legal claims, as well as on the project where they advocate for mediation instead of litigation. Since then, there are 2 new projects that you can go and read if you are interested. So you go to their website and you search for Project 125, because they are asking for comments in order to change prescription. And there's also a Project 142 where they discuss legal fees. Remember that the Law Reform Commission, they make documents of these projects, and then it is sent out to the public for comments. So people can comment and say whether they agree or disagree, and then they get all the comments, and then eventually one hopes that it will go towards change in the legal world. But I do not want to be negative or whatever, but they had a project concerning euthanasia for many, many, many years, and nothing has changed since. So although I have respect for the hard work they're doing, the wheel, according to me, is turning a little bit too slow. But it's still interesting. As I've said last, the project on medico-legal claims, there you get a lot of information and a lot of cases and how long the cases took in medical negligence. And the same with the one where they are now proposing for mediation. The only interesting thing where I disagree with them is that they're asking for comments, and you will see in the Van der Walt case, Van der Walt said that he should be measured against the yardstick of the profession and not law in general. In other words, he came with the absurd comparison and say that a doctor whose patient dies should not be treated the same as a person who drove drunk and a pedestrian died. He said that they must be treated as doctors different. And then, fortunately, the Constitutional Court said, no, everyone is equal before the law. Why should a doctor be measured against a different yardstick than a drunk driver if both of them were negligent and someone died? And I completely agree with that. But in the law reform project, where they advocate for mediation, they sort of also advocate that doctors should not be criminally liable. And I just completely disagree with that. But as I say, you can make up your own mind. Then concerning new developments, last time I told you to go to the website of the Constitutional Court, because you can actually on YouTube follow the cases. Since we spoke last time, the judgment was given in the NVM versus Tembisa Hospital. The judgment is now there on their website. Very interesting. It wasn't successful, but it will be good for you to go and read, as it is very fresh and new, and the judgment came out in 2022, so you can learn a lot from that judgment. Then the next one, the MEC for Health, Social Development Gauteng, TM, on behalf of MM, that was in the Supreme Court of Appeal. That is an interesting case, as I feel the lawyers messed up, as they claimed completely the wrong things. They claimed in general, and you cannot in medical negligence claim in general. You have to be specific with your claims. I have written with a colleague of mine a case discussion on this case, and that will be published in November in the Journal of Contemporary Roman Dutch Law, or in Afrikaans THRR, and I assume that most legal firms get copies of that journal. But for those of you interested, you can ask me and I can give you what we've written, even though it is not published yet. But there I indicate that I feel the lawyers made a mess of that case. Then just remember what I said last time, the voice of the unborn baby. We are still waiting for that judgment from the Constitutional Court. That is where if you have a miscarriage before 26 weeks, that the fetus is all automatically medical waste. After 26 weeks, it is considered a stillbirth. So we are challenging that in the Constitutional Court and say that every woman should be given a choice whenever there is a miscarriage, whether she wants a burial or not. So that is still awaiting in the Constitutional Court. Then Mashinini versus MEC for Health. That one connects with the DZ case on the payment of a lump sum or in installments and with services. So just take note. I just give you these cases because you can see it is all 2021, so it's new. It is new. And then the one Gauteng versus PN, I will discuss that one later because that's very interesting, but I'll speak about that one later. Okay, so we're quickly going to go back to contract or delit. And for those of you not so well known with the law, just take note and you will see that we sometimes speak of common law and sometimes of legislation. So the common law is all the law that is not written down, and it is the law of a non-statutory origin. And the law of contract and the law of delit forms part of our common law. An obligation gives rise to the right of one party to claim the performance of a corresponding duty from another. And the main sources of the common law of obligations are the law of contract and the law of delit. Those of you with LLB degrees, you will know this, so I'm just refreshing your memories. And the delit is an act of a person that is wrongful and culpable way causes harm to another, and in a culpable way causes harm to another. So a contract is easier to understand because there's a contract, there was consensus, the people had contractual capacity, it is possible to fulfill the contract is broken, you can now institute action. A delict is not that clear, it is when a person's rights have been violated wrongfully and it gave cause to harm. Okay, so all medical practitioners are required to exercise a reasonable degree of skill and care in the provision of treatment, and that will fall under the law of delict. In other words, you will have a contract with the doctor. If you go to the doctor and you ask for treatment, and the doctor agrees and started treating you, there is a contract, because the contract need not be in writing. It can be a tacit contract by the way you act, so you can establish that. But at the same time, according to the law of delict, the practitioners are required to exercise a reasonable degree of skill and care in the provision of the treatment. Sorry, I'm just drinking some water. So this is background. Okay, now, today we're focusing on medical negligence, and we're focusing mostly on delict. But remember, you can sue on the basis of a contract or a delict or both. Remember what I said last time? If you sue on the basis of a contract, you can only claim patrimonial damages, real damages. You cannot claim for pain and suffering. Whereas if you claim on the basis of a delict, then you can also claim non-patrimonial damages, and you can claim pain and suffering. So most medical negligence cases are claimed on the basis of a delict. Sometimes you will see it is contract and delict, but mostly it is delict. It is, you will remember from last time or from your study material, it is that one case, if I remember correctly, the Edward case that was based on a contract. The lady went in for a sterilization that was never done, and she fell pregnant again. So she instituted action against the public hospital for they have broken the contract. They said they will sterilize her. They did not. So she instituted action on the basis of a contract, and therefore she could not claim pain and suffering that she went through because of the pregnancy that she actually did not want. Okay, so what are the requirements for a delict? There must be an act. It must be wrongful. There must be causation between the act and the damages that eventuated, and there must be fault. Now, fault can be intent or negligence. So in the field that we're studying, it will mostly be negligence. I don't know of any doctor that will intentionally hurt or kill or be the reason that a person is paralyzed. So fault in this instance will be negligence. Now, I repeat this over and over and over again. And then a lot of times students or attorneys or advocates contact me and they give me a scenario, and then they ask, what is my opinion? Is there a case to be made out or not? And then I just answer them, go back and see whether you fulfill all the requirements for a delict. Was there an act? Was it wrongful? Can you prove causation? Of course, there was negligence. And then what are the damages? The most difficult one is to prove causation. Wrongfulness is when there is a feeling that public opinion will cry out that the person must be punished. So wrongfulness is not clear cut. It will depend on, from case to case, whether there is a feeling that the person should be punished. What he did was wrong. So that is not the big problem. The big problem is causation. Because if you cannot prove that the act is the cause of the damages, there is no case. So always remember that if you cannot prove that the act is the cause of the damages. Now, it sounds simple when I explain it to you, but it is not that easy. And I'm going to give you an example that just got into my mind. There is a court case, the Lewitz case, and you will get the citation at the end of the lecture. The Lewitz case, it's ordinary husband and wife. They had 3 children. They didn't want any more children. She went for a sterilization. The sterilization was not performed correctly and she fell pregnant again. So then she went and she said, but we didn't want this child and we can't actually afford this child. So the public hospital then said, but on socioeconomic um, um, on a socioeconomic basis, you are allowed to have a legal abortion. So husband and wife spoke to each other and they said no. They cannot do that. It is against what they believe in. It is against their religion. So they will rather accept the baby. And then, unfortunately, while she gave birth, things went terribly wrong. At the end, the baby survived, but the mother ended up in a vegetative state, which means she's connected to machines. She's like what we say, a vegetable. She can't think, she can't do anything for herself. So there's the father with 3 children and a newborn baby, which they didn't plan for. They went for a sterilization that was messed up, and now his wife is in that vegetative state. So they instituted action, and the state came with the argument and said the fact that they didn't opt for the choice of the abortion broke the chain of causation, as the sterilization was too far removed from the damages they suffered. But fortunately, the court overruled and said no. If if it wasn't for the failed sterilization, she wouldn't have fell pregnant, birth wouldn't have taken place, and she wouldn't have ended up in a vegetative state. So it is remoteness of damage, but in that specific case, the causal link wasn't broken. But I warn you now, when you are faced with facts, your most challenging part will be to prove causation. Okay, so remember that. What is the test for medical negligence? Now, this you should know off by heart. If you walk past me in Menlyn Mall and you recognize me, the first thing I'm going to ask you is, what is the test for medical negligence? Because you should know this off by heart. This is the shorter version. In your study material, you will see the full test. And if you read court cases, you will see that they quote a court case, Kruger versus Coetzee, in which the test was established. But it basically boils down to how would a reasonable, competent practitioner, now you can distinguish between a general practitioner or a specialist in that branch of medicine, have acted in a similar situation. How would a reasonable, competent practitioner in that branch of medicine have acted in a similar situation? In other words, let's go to Van der Walt. The lady gave birth. There were tears. She was ripped open from her vagina to her anus. The doctor saw that. Now the question is, what would a reasonable gynecologist have done in that part of medicine, which is gynecology, in the similar situation? Would a reasonable gynecologist have stitched her up loosely by a torchlight and left while she was still bleeding? Or would a reasonable, competent gynecologist have moved her to theater where there's excellent lighting and stitched her up perfectly so that the bleeding could stop? So clearly, when we hear this and we read Van der Walt, we can come to the conclusion that he did not act as a reasonable, competent practitioner. But that is our feeling. It is my feeling, Professor Slabbert. It can be your feeling. That doesn't help. We must get a person in that field of medicine. So we need another gynecologist to come and testify on what is accepted in their specific profession as being reasonable. In other words, to prove that the person acted reasonable within the circumstances of that branch of medicine, you will need an expert to come and prove it, to come and say he either did or did not act as a reasonable, competent specialist or general practitioner. And that is the problem. That is a problem. Because if you do not have an expert, you do not have an independent person to look at the facts and say what should have been done and what was not done. So once again, when you go back, just remember that the Van der Walt case was a criminal case. It was not on the basis of a delict. It went to a criminal court. But the state called an expert witness. Dr. Van der Walt did not. And I want you to think in your own head, why didn't he? Why didn't he call his own witness, expert, to come and say he acted as a reasonable, competent specialist? My feeling is because he would never find someone because he did not act reasonable. But yeah, you need an expert witness. So you cannot win a medical negligence case without using an expert witness. Now, where do you find them? Let's say you have a client that comes to you, you go through the facts, you do the test of the requirements of a delict, you see that you can answer all the questions, you feel you can prove causation, all of that. Now you apply the test and now you need an expert. Usually you can find them at universities. For example, the professor of obstetrics and gynecology or the professor of oncology or the senior lecturer in some or other field or the person training the nurses. So that is a way to start. Just be careful that the professor is not so old and so outdated that he is not practicing anymore, because then that can be something that the defense will put to the expert and say, for example, Professor Slabbert, yes, you are a professor in obstetrics and gynecology, but when last did you perform a birth? When last were you responsible while a birth took place? And if I say, well, 15 or 25 years ago, then of course the defense will work on that and say, but how much do you know? Are you keeping abreast of new technology? Do you still know what the pressure is in an operating theater, etc.? So try to find a professor or a known person in the field who are still in the field and still practicing. So that is a good way to start. Or you can, and this is now just unofficial, but you can go to the website of SAMLab, the South African Medico Legal Association. This is a voluntary association, not for profit. And it's an association where medical people and lawyers come together and they have lectures and they discuss problems, etc. But on their website is a list of people who indicate and who are willing to be experts. People are not always willing to be experts because they do not understand the court system. Sometimes they show up, they've taken leave, or their practice is standing still, and then the court case gets postponed and they feel their time has been wasted. So it is difficult to get experts, but these people on that website, they do it usually, and they know how the court system works, and they are willing to testify. It includes physiotherapists, speech therapists, psychologists, psychiatrists, all these people you will find. They're not just doctors per se. Okay, so expert witnessing. Remember the judge that is the referee. and the court case takes place in front of him. Remember, we've got a accusatorial legal system, meaning that the judge is not involved. So the two teams, the two legal teams, the one for the plaintiff and the one for the defendant, they must bring the case in front of this judge, and then the judge have to listen to everything. The judge is allowed to ask questions for clarity, etc., but he does not form part of the actual cross-examination or the questions. Now, if you have a plaintiff and a defendant, and both of them have excellent expert witnesses, which team or which one must the judge favor? And that is explained in the Supreme Court of Appeal case of Michael versus Linkfield Park Clinic. And the bottom line is that the judge will go with the expert who has logical reasoning and who can defend his or her view that they express as an expert. But their reasoning why they come to a certain conclusion is logic, and the judge can follow it. So that one, the judge will favor. But the guidelines are given in much more detail in that case of Michael versus Linkfield Park. So if you are practicing as a medical law attorney, you have to read that case. You have to take note of that case. And then just for interest, as I've said, on Friday or Saturday, and there's a long weekend coming up now when you have absolutely nothing to do and there's no Netflix that you want to watch, read court cases because they are so alarming and interesting. And the case of Oppelt is one of those. It is a rugby player that got hurt his neck and he was moved from pillar to post and then eventually ended up in court. There were two teams of expert witnesses, and the court went with the one group, and I feel I will go with the other group, but you can decide for yourself. So the case is important because it indicates the different views of experts. And it is funny when you read a case, even though it's not verbatim, but you can get a feeling while reading the case whether the expert was arrogant, whether the expert think too much of himself or not, or whether the expert is there to assist the court, or whether the expert is a hired gun. You can get that feeling by just reading the judgment. So if you want to read something very interesting, you can read that Oppelt case. And then, of course, you cannot actually practice medical negligence cases if you do not have that book of Van der Heever and Lawrenson, Expert Evidence in Clinical Negligence. That book is excellent because it explains to you as an attorney how to negotiate with an expert, how do you decide on how much he or she will be paid, what is expected of an expert, how do you prep your expert for court. Also an interesting book to indicate to you how do you request documents from hospitals in order to prepare your case. So really, really, really a very valuable book. I hope it is still available at Utah. Unfortunately, Pat van der Heever, he was an SC advocate. He passed away and he's not with us anymore. But the book is excellent and it will help you a lot. I hope that while I talk, you make notes, and I will have ample time afterwards for questions. I'm just carrying on and keeping my eye on the watch so that those who want to leave can leave once I'm done, and then we can have a discussion and I will listen to all your questions that you have. So just keep it for last and we will discuss it. Okay. So how do you prove medical negligence? It is on a balance of probabilities. And what is the difference between that and a case in a criminal court. In a criminal court, you have to prove beyond reasonable doubt. So that is more difficult. A balance of probabilities means that it must be 50% or more possible that it could have happened. So you have to prove it on a balance of probabilities. Of course, the plaintiff, he who alleges, must prove. And you have to prove all the elements of a delict. You have to prove all the elements of a delict. There was an act, it was a wrongful act. You have to prove causation. You have to prove fault in this and negligence, and then that damages were suffered. So there was negligence, someone suffered damages. The damages suffered is causally linked to the negligent conduct. And I say again, causality is the most difficult to prove, and make sure you understand this. And the only way you can read the theory and you can see there's legal causality and factual causality, but the penny will only drop if you read a lot of cases and see how the court applies it. They also speak of the but-for test. But for the negligence, the damage wouldn't have eventuated. So keep that in mind. I'll come back to that just now. There are certain factors that can influence medical negligence per se. And the first one is imperitiae culpae ad numerator. So you needn't know the Latin off by heart. No one's going to ask you that ever. But it basically means that a GP acts as a specialist, or one specialist acts as a specialist in another field. That is unprofessional conduct, and it is not allowed in your registration with the HPCSA. In other words, if I'm a specialist in psychiatry, I cannot go and say that I'm a specialist surgeon as well, unless I have both qualifications. But the most often that this happens, and it usually also happens more in towns, not so much in cities, but in towns or more rural areas, where you only have GPs, general practitioners, and then they start acting as a specialist. For example, you might have a general practitioner that will do breast enlargements, and that is not allowed, because a breast enlargement should be done by a plastic surgeon. So if the general practitioner does a breast enlargement and something goes wrong, the GP will be tested against the yardstick of a plastic surgeon. In other words, he will be tested higher because he acted out of his scope. And then it will be much easier to prove him guilty. So the negligence will be measured against the standard, what that was expected from a specialist. And the case that I refer you there to is Frick versus Scholes. And it is a case that happened in the Gauteng High Court. And what it was, there was a lady with problems, and they had to perform a gastroscopy and a coloscopy. And the doctor did it, but the doctor perforated the plaintiff's colon. And then the plaintiff was in need of a lot of more operations to correct the initial fault. And then she instituted action against the doctor. And then in court, it was found out that the doctor was only registered as a general practitioner. She has passed all the examinations as a surgeon, but she did not complete the internship as a surgeon. And therefore, she could not advertise or do the work of a surgeon. And therefore, she was found guilty of negligence because she, as a GP, did the work of a surgeon. And that is not allowed in our legal system. Now, there's something else. It hasn't been applied in court cases. I don't know. If you know about it, then you can tell me. It was done in the Van Wyk versus Lewis case, which is a 1924 case. But it is called the locality rule. And this rule basically states that the area where you practice has an influence on what happens. For example, can you expect the same diligence from a doctor in Cape Town, let's say a cardiologist like Chris Barnard used to be? Can you expect the same from a cardiologist in Bella Bella than what you expected of Chris Barnard? Can you hear the difference? The one is practicing in a city with all the necessary equipment, etc., whereas Bella Bella, Sheshegu, Lichtenburg, Mafeking, any one of those places might not have the same. So there are two schools of thought on the locality rule, whether you should distinguish or whether you should not. So it came out a little bit in S versus Timbani. And what happened there, you will see it's a SCA case. So it's a Supreme Court of Appeal case. So the appellant was convicted of murder because he shot his girlfriend. So she went to the hospital, and because of negligence in the hospital, she contracted septicemia, and she eventually died because of septicemia. So the appellant contended that the hospital staff and the doctors were grossly negligent, and this broke the chain of the causation between his attack and her death. He said there was a novus actus interveniens, a new intervening incident. And therefore, he said that he shouldn't be found guilty of murder because the septicemia caused her death. But the trial found the medical negligence did not oust the causal connection between the shooting and the deceased death. So that is just something that they did not address the locality rule per se. But if she went to another hospital, then she might have survived. I refer you there to an article that Professor Carstens, who is the guru of medical negligence law, and he's at the University of Pretoria, and he wrote an article that was published in the South African Public Law Journal. If you want to, you can read it. You can also look at the case of S versus Counter. Those are extra information. But in Van Wyk versus Lewis, 1924, the two things were discussed. Sorry, I'm just quickly going to go back. And the one school of thought say, it is there in your study material, the one school of thought say, all doctors get the same training, and therefore you should expect the same treatment from all doctors, irrespective the circumstances. The other school of thought say, no, you should distinguish between a doctor practicing in Cape Town versus a doctor practicing in Lephalale. This is very interesting, and I think this is also an area that needs a little bit more research, especially in a country like South Africa, where there is such a distinction between the haves and the have-nots, and the distinction between a private sector and the public sector. And there's no specific answer. I can't give you a specific answer, but should the instance arise and you can argue it in court, I think it will be very interesting to see whether you can hold the people responsible for negligence the same if it happens in Johannesburg or if it happens in Chris Hani Baragwanath Hospital, whereas it happens in a private, let's say, a Morningside clinic. I personally feel there is a difference. There is a difference because of infrastructure, because of resources, etc. Yes, all doctors get the same training, but all doctors do not get the same exposure, and all doctors do not get the same equipment. So I just want you to take note of something like the locality rule, and in the right instance, I think it is worth arguing locality should the circumstances allow for it. But you will see the detail in your study material. Sorry, I'm talking so much. I feel so sad if I think you have to listen to me the whole time. So I'm just drinking water, but today I have to give a lot of information, and don't be scared if you feel completely lost. Remember, all of this is in your study material. I'm just adding a little bit of flavor here and there, and you will receive the slides. So don't panic if you feel what I'm telling you tonight is too much. You can at your own time go through all of it. Then remember, in medical law, negligence is negligence. You will sometimes hear that people speak of gross negligence. That has no bearing in order to find a person guilty or not guilty. When you have proven negligence, in other words, you proved all the requirements of a dealer or you proved it in a criminal court, it doesn't matter whether it is gross negligence or just negligence. Gross negligence might have a bearing when it comes to sentence. In other words, if it was just negligence, then the sentence can be 5 years. But if it can be seen as gross negligence, then maybe the sentence can be 10 years. So it has a bearing there. But in order to determine whether there was negligence or not, it doesn't matter whether it is gross negligence or just plain negligence. Then there is also something which is called contributory negligence. Contributory negligence is where the plaintiff institutes action and then the defendant comes and say, but you contributed to your own pain, and therefore we are not going to pay out all of the amount. Just for interest sake, for those of you that is not so familiar with the law, you will see the case that I cite there is Dube versus Administrative Transvaal, 1963. So you must remember, in the old South Africa, it was the 4 provinces and the head of the province was the administrator. Now we have 9 provinces and the head of the province is the premier. So if you see the administrator, you must just know that it is old. It is still part of the old South Africa before 1994. So in that specific case, Mr. Dube's elbow was fractured and the arm was set in plaster, but the plaster was too tight and his arm eventually had to be amputated. And then the hospital said, but he didn't come back soon enough for them to take off the plaster. So he contributed to the fact that the arm must now be amputated. But the court overruled it and said that the hospital didn't indicate for him on his level of intelligence to understand. He didn't know in which instance he should go back. He thought it was normal that it would be stiff, etc. And then the court said he did not contribute to the negligence. You will find this, if I think quickly of a case, Suleiman, I'll draw your attention to it later. That is where you will see that the hospital and the doctor is sued because they say both contributed to the negligence. And then we will fall back on the apportionment of damages. And there will be, for example, the hospital was 80% negligence and the doctor was only 20% negligence. So I will draw your attention to a case where that happened. So you can also see S versus Mogeti, that is just extra. You can see it happened in 1990, so it's more recent, and it went to the A, which is the Appellate Division, which have now changed to the SCA, the Supreme Court of Appeal. Then error of judgment. If, for example, you go to a doctor, there's a lump in your breast, they take x-rays, and he say, no, it is just a swollen gland or something, and he misses that it is actually cancer. In other words, he made an error of judgment. That is not per se negligence. It is not per se negligence. Remember the test, we will ask, would the ordinary reasonable doctor in the same circumstances have diagnosed it as cancer or not? And only if you can prove that by using an expert in the field to come and say any GP or any radiologist should have seen that it is cancer, then there might be negligence. But the test must be done. It is not per se that if there's an error of a judgment, same with a misdiagnosis, that it is automatically medical negligence. You still have to apply the test to check whether the reasonable, competent doctor would have made the same mistake in the same circumstances. Okay, so now we focus on criminal cases. That is also in your study material, and I've spoken a lot of the Van der Walt case, so you can read it now on your own. Focus on the Constitutional Court case. There's also another case, S versus Kramer. You can read that. That concerns an anesthetist. And remember that these cases must be proved beyond reasonable doubt, even though it is negligence. Whereas in a civil court, when you go on the basis of delict or contract, you only have to prove on a balance of probabilities. Now, just for interest, when you prepare a case, always remember that when you look at an act, what does the act say? For example, if it concerns informed consent, which I will deal with in detail in the third webinar, then you will look at the National Health Act, which states how informed consent should be, how you should get it from the patient and where do you get it if the patient cannot give it. But you must always, always, always consult the regulations to an act. In any act, there will be a clause that will say the minister is allowed to make regulations. Now, briefly, what is the difference? Legislation are the laws made by Parliament. It takes a long time. It starts in committees, then it is published, a green paper for public comment, then it is published as a white paper for public comment, then it is debated, and when it is accepted in the National Assembly and the Council of Provinces, then the president signs it, then it becomes the law. But the law enables the Minister of Health to make regulations, and that does not go through the parliamentary process. But it's got the same force as the act, because the act you can see as the skeleton, and then the regulations are the flesh that completes the whole issue. Now, this case of S versus Frederickson, it happened in the Free State High Court, was very interesting. It was not about medical negligence, but it is a case which showed that the judge only looked at the act, the judge and the advocates, and they forgot about the regulations. This case concerns human tissue in a freezer. This was, I'm not sure, a Swedish or a Denmark or a guy from those areas in the world. And he was here in the Free State. And he then got women from Lesotho to his house where he entertained them and he gave them a lot of alcohol. And then he negotiated with them a huge price, and then he circumcised them. So he took their clitorises, which is human tissue, and he put it in little containers in his freezer. But apart from that, he did a lot of other things as well, having weapons without being licensed, etc. So it went to court and he was charged with having human tissue in his freezer. And then the defense said, but he cannot be charged because it's not a crime, because the National Health Act do not have punishment clause. Those of you who can still remember in criminal law, you were taught nullam puna sine lege. You cannot be punished unless legislation indicates what the punishment must be. In other words, if a person mows his lawn on a Sunday morning, you cannot take him to court because there's no law that say you are not allowed to mow your lawn on a Sunday. But the Act, the National Health Act, did not have that punishment clause. But the Act gave the minister the right to compile regulations, which he did. And in the regulations, there was a punishment clause. So that case is just interesting. As I say, when you have nothing to do, you can read it and see how it was argued. And it is actually a travesty of law because the guy were then not charged on those for those crimes. He was charged and found guilty for others, but they withdraw the fact that he should have been guilty for having human tissue in the freezer because they said there was no penal clause, yet there was a penal clause in the regulations to the Act. So that is just a little bit of interest for you. Let's go back to what I have emphasized now so much this evening: causation, causation, causation. Sorry, I'm just drinking water. And you will see in your notes that we distinguish between factual causation and legal causation. Factual causation is easy sort of to determine. You just ask, did the conduct cause the damage? And you will look at the facts. She was not sterilized. She is now pregnant again. So the fact that the gynecologist did not perform the sterilization accurately, she is now pregnant and the baby is born. But for the failed sterilization, she would not have another child. So that is more easily to distinguish. Legal causation is, does it cry out for someone to be punished? The act and the harm is close enough for legal liability. So the act and the harm is close enough. And now remember, I told you about that Lewis case. That was the remoteness of damage. The damage was remote. It was a failed sterilization, a pregnancy, a birth, and as a result of the birth, she ended up in a vegetative state. So there is quite a remoteness of the damage. Yet the court in that case, because of those circumstances, said, but for the failed sterilization, she would not have given birth and she would not have ended up in a vegetative state. And because of the sadness of the case, one feels that there should be legal liability for the doctor who did not perform the sterilization correctly. But if you want to understand and see how the courts have argued causation, you can read the case of Lee versus Minister of Correctional Services. That case concerns a guy that went into prison and contracted TB. And had to prove that if he was not incarcerated with so many people, he would not have contracted TB. There you will see a huge discussion on causation, and that will help you should you be faced with a case where you are not sure whether there is causation or not. Then S and another versus the Life Healthcare Group and another. That is the case that I spoke to. It is a doctor, Dr. Suleiman, and the healthcare group. And what happened there is Dr. Suleiman, this woman saw a gynecologist during her whole pregnancy. On the day that she was supposed to give birth, he was not available. So he asked Dr. Suleiman to stand in for him, and he left. The nurses called Dr. Suleiman and said that the lady is now going into the birth process, and he gave advice over the phone. They called again, and he eventually only arrived at about 9 o'clock that night at the hospital. He was called at 11 in the morning. And then there was chaos, and a baby was born disabled. And then the question was asked, who was responsible? And his argument was, but he did not have a doctor-patient relationship. It was not his patient. It was his colleague's patient. But the court argued that the doctor-patient relationship between him and the patient started when the nurses called him at 11. He disputed that. And then he said, but the nurses should have called him earlier and insisted that he should come. So there was negligence on their side as well as on his. And that is why I say the apportionment of damages and contributory negligence, you will also see something on that in the case of Suleiman and another versus the healthcare group. Just interesting. It's not always that things go wrong in the public sector. This is happened in the private sector. Okay, so just to reiterate again, who has the onus of proof? The plaintiff, and the plaintiff must prove on a balance of probabilities. In a criminal case, it must be proven beyond reasonable doubt. Now, there's a very interesting thing in the legal system that also came out in the case of Van Wyk versus Lewis, that 1924 case. And you have to read that case because it's the locus classicus, and you will still find cases today in 2022 that will refer back to Van Wyk versus Lewis. There is something like res ipsa loquitur. And the direct translation is that the facts speak for itself. But you must be careful. This is not an accepted maxim in the South African medical law unless it is specifically proven. Now, what do I mean by that? Let's say, for example, you had your abdomen cut open for an operation, and then afterwards you feel pain in your abdomen and the pain become worse, and you go to another doctor and the doctor say, no, he must open it up again, and he opens it up only to find a swab in your abdomen. A swab is those tissue things that they use to stop the blood. And they're not supposed to leave it behind in your body. The nurse is supposed to count how many swabs they have at the beginning of an operation and check that at the end, all the swabs that are blood drained, they must count them again and see that everything was taken out of the body. But sometimes it happens that one is left behind. So the doctor opens up, finds the swab, it has now become septic, removes it, etc. Now the patient say, well, I'm going to sue doctor number one because he was negligent, because he left a swab in my abdomen. The facts speak for itself. If he didn't leave the swab in my abdomen, I will not have the pain. I will not need another operation. That is not accepted in South Africa. You must go and look at the specific facts of the case. Why was the swab left. Maybe there was such an urgency that you had to close the body, otherwise the person would have bled to death or died, whatever. So it was, there was pressure to close the wound as soon as possible. There was no time to check thoroughly. And in order to save the patient's life, unfortunately, the swab stayed behind. That is what happened in Van Wyk versus Lewis. So you cannot accept that if the facts are so clear that it is negligence per se. And I think you will know by now that I'm warning you constantly that when something goes wrong in a hospital with a doctor or a nurse or a private hospital or a public hospital, if something goes wrong or there's a bad outcome, it is not necessarily negligence. Negligence will have to be proved. You will have to prove that the act is the cause of the damages suffered. Now, the only case where this res ipsa loquitur was applied directly is in that N versus MC case. And what happened in that case? It is the medical nursing staff of a provincial hospital attended to a baby while the baby was being born. But during the birth, the baby's arm had been cut. It was a cesarean section, and in this process of cutting the abdomen open, the baby's arm was also cut. And she was removed to the neonatal ward without the mother even seeing her, because the mother was then also bleeding and the mother needed desperate attention. So she didn't even see her baby. And only after 3 days could she go and see her baby, because she had a wound herself that was draining, etc. She thought that someone was looking after her baby. She couldn't do anything. And after 3 days, she was informed that her baby was screaming with hunger. She found the baby in an incubator, and not even the wound on the arm was attended to. And that was just too much for the judge. And Judge Bertelsmann said, res ipsa loquitur, the fact speaks for itself. This was blatant negligence. How can you leave a newborn baby with a wound? You do not attend to the wound. You do not feed the baby. The poor mother has her own wound to be looked after. And she instituted action, and she was successful. There was expert evidence, but the judge said on the maxim of res ipsa loquitur, in this case, the facts spoke for itself. It was blatant negligence from the nursing staff. Okay, then you must also remember vicarious liability. Right at the beginning, I told you that doctors and nurses in the public sector are employees. Therefore, their employer, which is the Provincial Department of Health, and the MEC is the head of that, they are responsible for all the actions of their employees, doctors, physiotherapists, psychiatrists, nurses. Remember, in the public sector, it is different. There, the doctors are independent contractors. The nurses may be employees, otherwise they are working for an employment service company, and you must establish that before you can sue the employer. Now, sometimes it is difficult if the doctor uses a locum. A locum is a doctor that stands in for the doctor whose rooms you are attending to, because he may be overseas on holiday, and then another doctor acts on his behalf, and we call that person a locum. Now, it is very important for you to distinguish whether the locum is an employee or whether the locum is an independent contractor. Because if you employ the locum as an employee and the locum makes a mess, you as the employer will be sued as well. But if you use a locum as an independent contractor and something goes wrong, then the patient must sue that locum. and you stay outside. Remember, this happens in private sector and not in the public sector, because in the public sector, all doctors and all nurses and all physiotherapists and all other related professions are all employees of the state. In the case of S versus Kramer, it was a case that involved a surgeon and an anesthetist. And in that case, it was said that the one is not the agent of the other. They are not employed and controlled by one another. Each performs a speciality of its own, and they do not account to one another. Now, this is very, very difficult. Sorry, I'm just drinking water. In Britain, in England, there is a principle, the captain of the ship. This doctrine is not part of South African law, meaning, for example, my husband had neck pain, so he went to an orthopedic surgeon who said he needs an operation. So it's the orthopedic surgeon. But because it's in his neck, they also need a neurologist. But of course, they also need an anesthetist. So there are three specialists, a neurologist or a neurosurgeon, depending on the circumstances. But there are, let's say now, three of them. Who is in charge? And if we look at what the S versus Kramer case said they are all independent from each other. So what happened specifically in the case of my husband, he went in the morning, he saw the orthopedic surgeon who got the informed consent. The neurosurgeon quickly came and introduced himself, but did not necessarily ask for informed consent. The anesthetist came and were more troubled that his account should be paid than getting informed consent. But never mind, all three of them, and my husband went into the operating theatre. So I was sitting outside waiting as a very loving wife, and I was knitting and I was knitting and I was knitting, and a nurse came up and down the corridor, and eventually she asked me, why am I sitting there the whole day? So I said, I'm waiting, my husband is in theatre, and I cannot leave until I know that everything is fine. And then she told me, no, but I will not know when he is coming out of theatre because he is going directly to the ICU. And I sat there and I said, why didn't anyone tell me? And that is the problem. Who was supposed to come and talk to me? Who is the captain of the ship? This is a real difficulty in our legal system, that all these specialists performing the operation together, the one is not responsible for the other. They are all three independent. Now, after that happened, I have asked a lot of doctors and specialists, and they say the anesthetist is actually the person that should come out and speak to the family and say that everything went well, etc. But it is not a fact that it should be. And this is a problem, because why do people sue doctors? Because they are angry, because no one talked to them, no one told them what happened in the theatre, yet their son died. Or no one told the husband what happened in theatre, yet his wife is dead. And that is a problem that needs to be addressed. I don't know how, but it is not part of our legal system. I think I told you last time about my hairdresser that had a blood problem. She was advised not to fall pregnant. She did. And on the day that she was going to give birth, all possible specialists were there: the obstetric gynecologist, the hematologist, the surgeon, the anesthetist, the general practitioner. And then her blood pressure fell and she needed oxygen, and they all went for the oxygen cylinder and there was no oxygen in it. So one of the specialists jumped on her and gave her CPR, and she survived. But the question is, who was supposed to look that the oxygen cylinder is filled. General feeling would be the head nurse or hospital management. The problem is that if something goes wrong, who do you sue? You will have to sue all the doctors, and then each doctor will have come and indicate in court why he should not be sued. But there's no captain of the ship. So keep that at the back of your minds when you're dealing with a case. Okay, let's think about this. Dr. Y has been working for a partnership of doctors. Partnership. Those of you that know labor law, you see the flashlights. Partnership. He's been working there for the past 2 years. He is paid per hour and they subtract pay as you earn. In other words, what can we conclude from those facts? That he's basically an employee of the partnership. Just side note, if you appointed a locum, you're not allowed to appoint him or her for longer than 6 months. But okay, so it's a partnership. The doctor has been working for them for 2 years. He's paid per hour. They do subtract pay as you earn, but there's no formal contract. And one day, there's a misdiagnosis by this Dr. Y, but he's acting in the employment of the partnership, and the patient dies. Dr. Y is held responsible. He has no MPS insurance. What now? What now? Okay, let's analyze it. It's a partnership. We've established that because he has worked for so long and he's paid per hour and they do subtract his pay as you earn, there's an employment contract. So he acted within his employment, his scope of employment, while diagnosing this patient, but he made a mistake and the patient died. Who will the patient sue now? It will not suffice to sue Dr. Y. Why? Because he has no insurance and he in person. Remember that when you are successful in a medical negligence case, it is not the doctor that pay from his or her pocket. It is their insurance that will pay out your claim. So if the doctor, and all doctors must have insurance, and the partnership should have established, and they should have put pressure on Dr. Y to have his insurance in place. But now he doesn't have it. But he's responsible. So it will not help the patient to sue him because he, as an ordinary natural person, will not have millions to pay for the misdiagnosis to the family of the patient who died. So you will sue the partnership. Vicarious liability. The partnership will be sued. And now what happens when you sue a partnership? All the partners. So let's say there was 4 doctors. You will sue all the 4 doctors in the partnership together for the damages that you have suffered. And they will have to go and recollect it again from Dr. Y if they ever could. So this is just a little bit of a scenario of what can happen. Okay, what are examples in short of medical negligence? Okay, misdiagnosis, a careless examination, and that is why they do today what is called, you will see this in newspapers and in journal articles, defensive medicine. The doctors nowadays will send you for a lot of tests, which is most of the time unnecessary, but they are so scared that they make a mistake. Unfortunately, it has also become a money spinner. So it is easy to say, you go to a doctor and you say that you have cramps in your hand and he immediately sends you for x-rays. And then you come back and you say, but there's nothing wrong. So there was actually money wasted. But anyway, doctors are scared of misdiagnosis and therefore they use defensive medicine, and unnecessary tests can be done, and that just makes the premiums for medical aids so much higher. Errors of judgment, but remember I said an error of judgment is not per se negligence. You must still do the test of the reasonable doctor. Then a huge mistake that a lot of doctors make is not getting informed consent. But leave that for the next webinar. Then we will go in detail on what is informed consent. Failure to refer. A doctor must refer. Remember, I told you that even in the public sector, if it's against your religion, and you remember you have the right to religious freedom, if it's against your religion to perform an abortion, you have to refer the girl to someone who will do it. You cannot just leave it. You have to refer. And then the biggest area where you will find medical negligence cases is in the failure to follow up after an operation or after the woman gave birth. So they will do the operation and everything will be fine. And then something goes wrong and the doctor will be called, but he will not show up in time or he will not pay the necessary attention. Septicemia will come in. You might lose your arm or your leg. So it's not necessarily negligence during the operation, but negligence after the operation. Huge area where medical negligence happens. Okay, and then of course it can happen in surgery where they perform an operation on the wrong leg or they break your jaw during an operation or they did the wrong procedure. But remember, there's nothing like res ipsa loquitur. The facts do not speak for themselves. You must look at the circumstances, all the facts, apply the test, and only then can there be possibly negligence. Okay, where does it happen? In obstetrics and gynecology, or wrong medicine being prescribed, or they used faulty equipment, or in radiology, they can burn you when they take x-rays, or there can be mistakes in blood transfusions. Remember, you're not allowed to give blood to a Jehovah's Witness, but if it is a child and the parents are Jehovah's Witnesses, the Children's Act gives the doctor, if it's a life and death situation, the doctor can do a blood transfusion because the Children's Act will protect him because the best interest of the child will overrule the religion of the parents. Okay, and then surgery, the local classicus of medical law is Castell versus de Greef. Also a case worthwhile reading because you will be referred back to it time and time again. Okay, how do you approach a medical negligence case? I'm drinking water and I'm apologizing again for talking so much, but we're nearing the end. And then we can engage in questions. Okay, how do you determine? First of all, you gather the facts from the plaintiff. Now you have two choices. The plaintiff can come to your rooms, your offices, and the plaintiff can verbally tell you what happens and happened, and you can make notes. Or you can send the plaintiff home and say, write down in great detail what happened. So the choice is yours. If they sit in front of you and they tell, then of course it's time consuming and they remember. People remember. People remember selectively. The plaintiff will only remember what he or she thinks is important, and they might forget a lot of other facts. So it may be a good thing to send them home and ask them to write down what happened, but not just what happened on that day. What is the history before? In other words, are there other sicknesses that was there before the person ended up in the operation? As many facts as possible, keeping in your mind that plaintiffs remember selectively. I usually, when I was still an advocate and I did criminal law and you interviewed the alleged criminal, the accused person, and you ask them what happened, they will most of the time tell you, I had only one beer. I had only one beer. And I want you to remember this, although it's a joke, because no man ever has just one beer. So then you know it is not the truth because it's never just one beer. So just remember that if the plaintiff tells you that she was perfectly healthy before she went in for the operation. She didn't just drink one beer, just find out a little bit more. Find out more. Gather as much facts as you possibly can. Then ask the client, and I believe in this. I don't think every attorney does that, and you don't have to. But I believe in asking the client, what does she want? Why does she want to sue the doctor? Is it because of revenge? Is she angry because no one spoke to her? No one explained what happened? She's looking for answers and she's angry. She wants to get revenge because she went in and she wanted breast implantations, and now her whole upper body is scarred. So she wants revenge. Or does he want closure? I just want answers. What went wrong? What did the doctors do? Why did it happen? I want closure so that I can live with the death of my wife. I might not understand, but try and explain to me what happened so that I can get closure or get answers for questions that I have. I do not understand. I took my child for an appendix operation. He was healthy. He was playing rugby. And the next moment you tell me he's dead. I want answers. So ask the client, why are they instituting the action? Then you get the hospital reports. And as I've said in that book of expert evidence, step by step, it is indicated how to get records if the people don't just want to give it to you. Remember, you can ask for the records. They will give you copies and you will have to pay for it. But okay, so you get the hospital records. Now compare it with the version you got from your client or from the plaintiff, and see where there's overlaps and see where there are differences, and see whether you can, with your medical ignorant eye, see something went wrong. So you get a picture of what is going on. Then you identify the law applicable. What is this case about? Is it a delict? Is it because of a contract? Is it because of the National Health Act? What is the situation? And then in your mind, can the elements of a delict be proved? Was there an act? Was it wrongful? Will you be able to prove causation? Was there negligence? And did someone suffer damages? Once you feel that everything is there, you now give that bundle of documents, what the plaintiff told you, maybe your notes that you have gathered, the hospital records, as many as you can, you give it to an expert. And once again, that book of Van der Heever will explain to you how to negotiate with an expert. So you give everything to an expert who will only look at the documents on the table. As an independent person who has expertise in that field of medicine, and that he or she will give you an opinion whether it is worthwhile to sue or not. And then you must remember, now you are starting to build your case. Keep in your head that the new court rules say that you must try mediation before litigation. If you want to determine more or less what the damages would amount to, then you can look at this book of Potgieter, The Quantum of Damages, and that will give you some diagrams or whatever. Otherwise, you will also need the help of a person, what are they called, that work with numbers? It will come to me, but you will get someone professionally to work out all the costs. Okay. Now, I came across this case, ME on behalf of MP, and it is a 2022 case of the 21st of January 2022. If ever there is a case that you must go through, and you will not be tested on this, and this came too late for the activities, but go to the trouble of going through this case. it is extremely interesting. It is in a public hospital. There was negligence. It's cerebral palsy. But they agreed, the plaintiff and the defendant, they agreed on everything. They agreed on the facts and the findings of the experts. So they went to court basically for the quantum and how to determine loss of earning capacity, past and future medical and hospital expenses, and general damages. So this case is not about the facts, because the parties agreed on the facts. There was a lack of oxygen, a baby was born with cerebral palsy. The experts confirmed, the experts on both sides were at idem that the lack of oxygen, the negligence was the result of a baby being born with cerebral palsy. So they went to court, agreed on the facts, and then went on to discuss the quantum. What is very interesting in this case also addresses contingency deductions. In other words, how do you handle it when you go on a contingency basis? What are you allowed to deduct? And should it be covered in the amount of damages or not? All those things are excellently put out in this case. The other interesting thing, the first time that what I've seen in medical negligence cases is that a trust is also discussed, the creation and the administration of a trust for this child. In the road accident fund, there's a huge problem. They pay out the lump sum and the lump sum goes to the family, and a year later, there's nothing left. But this child that have to live with cerebral palsy will need therapies and money for the rest of that baby's life. So therefore, the attorneys are allowed to create a trust and to administer that trust on behalf of the child, so that the child will always have access to money. The other interesting part of this case is the experts, the number of experts, and what all the experts said. It is absolutely amazing. There were 21 experts. And remember, all of them must get paid for their expert opinion. My opinion is sometimes they go too far. But if ever you go through a case that will show you everything that you need to know concerning quantum or how do you charge damages, you have to read this case. It is the most important and the best one you will ever come across. Okay, I'm going to end. The next few slides are just lists of cases that you can go through. These are cases where there was bad lawyering, but on the same side, medical negligence. Lushaba. There are 3 cases of Lushaba and then eventually a constitutional court case. These 4 cases are the saddest that I have ever experienced. I've also written about it. It is really, really, really sad. And once again, on a technical point, it went to the Constitutional Court. This is more interesting than the Fast and Furious on Netflix, to read these 4 cases of Lushaba. Remember, these slides will be made available, so don't worry, don't try to write it down. You will have ample time to go through it on your own. And then if you want to see specific cases, how to handle expert evidence, you can read those cases, as well as this case that from 2022 that I have highlighted. If you want to see cases on causation, then you can go through those cases. If you want to see where this res ipsa loquitur was specifically not applied, even though it looked obvious that there was negligence, you can read those cases. If you want to see a contract, it's that one case. The remoteness of damage, I've spoken about the Lutz case. Warning of the rare risks, you can see that case. Where res ipsa loquitur was applied, a novus actus interveniens, where there was misdiagnosis, contributory negligence, all those things see in the private sector, they also mess up, not just in the public sector. There you have some cases, and there you have cases on quantum. And thank you. Now I must just get out of this and switch on my camera. Okay. Yo, I have given you a lot of information. I hope you kept up with me. I went quite fast, but remember the slides will be available on your website. Okay, I am done. You can now ask questions. So you can raise your hand and then just remember to switch on your mic when you ask a question. There must be questions, or are you so overwhelmed with all this information? Let's see in the chat room. Let's just quickly see. Okay, there's no specific. Anyone with a question? Are you coping with your activities? Yes, Sam, talk to me.
Hello.
Just switch on your mic.
Yes, I switch it on.
Okay.
Can you hear me?
Okay, speak a bit louder.
Can you hear me now?
Yes, I can hear. I can hear.
Yeah, I wanted to ask you about the lump sum. I heard you say
Yes.
the courts, I'm not sure if I heard you, they are reluctant to order the lump sum. Instead, they prefer to to follow maybe the latest model as to how the plaintiff should be compensated.
Okay. You must go and see the DZ case. In other words, go through all those cases that I've listed and find the DZ case and the Mashinini case. And they explain it there. What the courts now say is instead of giving a lump sum, for example, for future medical costs, they will rather give an undertaking, and the judge will monitor that whatever future medical needs the child may have, physiotherapy, dental surgery, whatever, should be supplied by the public sector. And money must not be given, services must be given. That is now, of course, they need to pay past medical expenses. If it's the private sector, then of course there are no past future expenses, except if they paid out of their own pocket for certain things. But the future medical cost will be paid in services. And pain and suffering or a loss of amenities of life, for example, if the actuary determined that this child could have become a doctor, because the parents are doctors and this child is clever, but now there's brain damage, etc. That amount of loss of earnings, they are now advising it must be paid in a staggered form as the need arises. Why? Because sometimes they claim millions, and if it is paid in a lump sum and the child dies a year later, can you see that all that money? Yeah. So they're trying to make it more realistic that the money goes for the child that needs it. So instead of giving all the money at once and the child dies and then the parents can do with the money whatever, they keep it back and they will pay it out as the need is. It depends from case to case. The Constitutional Court in the DZ case just opened the doors that there's a possibility to do that. Now, every judge in the court with the specific circumstances must make a decision whether he's going to order lump sum or services or pay in staggered form. But you will see once you go through those cases, if you don't find the cases or the answers, send me an email and I will forward all those cases to you.
Okay, that's great. Thank you very much.
Okay. Anyone else? Those of you who would like to leave, who do not have questions, you don't have to apologize. You can just go. I won't be offended because I know everyone is under pressure for time and data and okay, let's see. Let's just see the people whether I can see a hand. Anyone, you can put up your hand. Okay. I see there's no questions, so good luck. Those of you that have done test 1, you are now nearly as clever as I am. Those who still haven't done it, remember you can still do it until the 12th of May. And then remember activity 1, 2, and 3, you must submit together as portfolio 1. And activity 4, 5, and 6, you put together as portfolio 2. If you've got any questions during the course of the module, then either email me or put your question on the forum. And if Bonnie cannot answer, she will refer it to me. Thank you to all of you. Sorry for me speaking so much. Next time it will be less information and we can interact more. But yes, good night and good luck.